whether you mean to or not. Okay? They quit and they get home and, oh, I still got my contact list here from the office. Or, oh, my email account, while it may be disabled, I still have the last 2 weeks of email on my phone. Okay? And included in that may be forms. It may be, confidential, customer information. There may be HIPAA, it has some health records in there. Who knows? So some way they're usually leaving some. It's awfully not. It's usually inadvertent. But employees will want to utilize forms, contacts, programming, and other information in their next job. That's another thing that you see oftentimes. I'm just going to shoot an email to myself on this, right? This form would be really helpful for that great new job that I just started. So I'm just going to email it to myself, get it out the door, okay? So you want to think about that. Trade secret considerations. Not all information, not all confidential information is automatically a trade secret, okay? The information including programming, formulas, programs, methods, techniques that employers have taken reasonable measures to protect. That's a trade secret. Again, the employers you have to take reasonable steps to protect that for it to be classified as a trade secret. Okay? So if you have proprietary information that you want to be deemed a trade secret under the law, you need to have a system in place to protect that information. Okay? And then loss of access to information, loss of stolen devices. Okay? If you need access to text messages for a lawsuit, you'll need to go through the employee or the service provider if they weren't safe. Okay? So loss of stolen devices. If I lose my iPhone, okay, we have the ability in our office to do a remote wipe on this device. So I can clear it. I can wipe it back to nothing. Okay? And so all of that confidential information that may be located is now gone. It's cleaned off, it's ready to go. Okay? Someone picks it up, opens, unlocks my phone, they're not going to get it. Okay? There's lots more potential risks and considerations here to think about. Litigation holds. Okay? You're sending out a litigation hold. When a person or business is aware of a claim or threatened claim, they have a duty to identify and preserve relevant sources of data. Okay? If your employees are only working on your company-owned devices and platforms, it's easy. Right? Because I know this is my device, this is my thing. Threshold questions of what devices and information the business has in its possession, custody, and control, as required by the Federal Rules of Civil Procedure. Okay? How do you define control when it's a personal device? Right? Is this now under the control of the employee or the employer? Okay? Some courts have found that if the employee can access the source during his normal day-to-day work, then the information is within the company's control. The 8th Circuit, the general rule is that a party must produce the information if it has the legal right to obtain. It has the legal right to obtain the information on demand. So there's not much case law on this out there. This Hatfield case, the New York Times was in a collective bargaining agreement with the reporters union to give up the rights and the reporters' notes and published material. If you look at this case, it's actually probably more the exception than the general rule. Okay. More things to consider. Okay. How about viruses, malware protection on the devices? What if a company or a employee's device actually, infects your company network with virus or malware? Okay, how do you deal with that? How about friends and family accessing the device and the information that came out? Okay. The data, inadvertent data getting uploaded to the cloud. A lot of you probably use iCloud. Again, I keep coming back to Apple, but it's what I'm familiar with. The iCloud service, right, where it automatically backs stuff up for you. Now, once that backs up into your personal backup side, could be company data, it could be, again, that confidential information that we were talking about. So how do you deal with the cloud backup? Okay, HIPAA and the Gramm-Leach Filey Act. Okay, record retention and management. The documents contained in the device need to be included in your document retention policies. So how do I, as an organization who is required to maintain certain information depending on the industry that I'm in, how do I make sure that employees' devices, that data is being a part of that, is becoming a part of that retention policy? Okay. So just lots of issues. I mean, it goes on and on. Here's the wage and hour issue that I was talking about earlier. Okay, there's a potential for off-the-clock work by non-exempt employees. Okay, if I'm an hourly employee, I'm a receptionist, or I'm someone that is not an exempt employee, and again, the company has somehow told me that it's important that I have access to my email. And now I'm off the clock, I'm not punched in, but I'm checking my email and I'm responding to work and I'm doing, you open yourself up potentially to wage and hour types of issues. Okay? If it's, again, you go back to whether it's encouraged or enforced, or if it's just an option. And it needs to be clear in your policies that if you're a non-exempt employee, you may have access to this information, but it's not required that you have access to it. Okay? So you have to be careful with that. It's just the amount of concerns and the amount of issues to look at just go on and on. Okay, equal employment opportunity issues, equal treatment. So if one employee can have access to their personal device and get their email and everything set up, then someone in the same position should have those same rights and abilities to get that information. Okay. Privacy concerns. You do not want to violate the Computer Fraud and Abuse Act or the Store Communications Act by improperly accessing an employee's private email. Okay. So now what if it's a private device, or it's a company device, either one for that matter, and an employee has their personal email account set up on it, and all of a sudden these messages are coming in, right? So you need to inform the employee that they shouldn't have an expectation of privacy. Okay? Criminal offense to gain unauthorized access to a computer and allows for civil damages if the damages are of the holder exceed $5,000. Under the Store Communications Act, this prohibits unauthorized access to email stored at an employee service provider. And this is criminal charges with civil remedies. Cannot use stored passwords saved in the device to access employees' email. Okay? So how many people set up their personal Gmail or whatever account on their phone? Okay? You don't ever have to you don't have to ever enter your password again, right? So now I'm an employer and I'm going to pull this device up, and all of a sudden I start accessing my employee's private email. Okay? You're pretty quickly going to be in violation of that Store Communications Act. Okay? So you have to be careful and know what's on those devices. Okay? All right. So technical possibilities. We talked a little bit about that earlier. What is possible, what is not possible from an IT perspective. Okay? How much can I limit? How much can I not limit? Okay? The technical possibilities of BYOD really depend greatly on the network infrastructure and management software that they're using on the back end. Okay? Management software can deploy system software and limit access to directories and files based on user permissions and security. Some can push email, contacts, calendars, to-do lists, things like that. Some can monitor text messages, email messages, SMS, and MMS messages. Okay? Virus and malware protection, and remote lock and wipe. Okay? Those are all things that vary depending on server software, server hardware, device software, device hardware. I mean, there's just a wealth of variables that kind of have to be vetted to understand what are your capabilities and what can you do. Okay? To try and make sure that we're separating business from personal. Okay? Limit and monitor data access. Some people can block certain websites and app access. That's again back to the Facebook thing. Okay? So some of the possibilities or some of the softwares allow for limiting access to Facebook, to Twitter, to LinkedIn, and all of that. Okay? And all of it will vary in IT capabilities. All right, here's some components of the BYOD policy. Purpose and participation. Which employees, again, these are things that you need to make a conscious decision on. Which employees are you going to allow to participate in the program? Will some employees with greater access to confidential information be required to use the company device? So you might have a two-tiered policy, okay? So lower level employees are employees that are accessing, generally accessing less important or less confidential information, maybe can use their own DY, can bring their own device and use that. Whereas other employees that are accessing more sensitive information or different information may be required to carry a company device. So that's another potential possibility. Okay? Address the cost reimbursement issue in the policy. Okay, so here's how much we're going to reimburse you on a monthly basis. If you need to buy a device, we may or may not give you money to help with the device costs. And it's a privilege that can change at any time. Okay, so I always recommend that you have a bring your own device policy. Maybe it's in part of an employee handbook. Okay, and when that employee comes on, you have them when they sign their employee handbook. Maybe they initial or they sign the acknowledgement of the BYOD side. Okay, and maybe they don't get reimbursed until they sign it, or maybe they can't. Maybe you won't set up their company email until they acknowledge it. Okay, so there are ways to make sure that you're covered and that you clearly communicate those policy expectations before they happen. So, I mean, all general employment-related policies will still apply from the user end. You know, off-the-clock work, I would definitely address ramifications of violation. So, if I prohibit Facebook and somehow you're able to get around it or you're using it, okay, what does that mean? Do you get a warning? Do you get 2 warnings? I mean, I would say corrective actions and terminations are all part of that policy, right? And how you're going to deal with violations of that policy or misuse, malware requirements, safety concerns, no driving while you're using your device, right? We don't want them texting and driving while they're on company time or on company business, okay? Because it creates all of these really gray liability issues that us attorneys love to live in. What will the IT people be responsible for, and what will the employees be responsible for? Okay, is it understood that employees are required to update the antivirus on their laptops if they're accessing the company network, or will those network or antivirus updates be pushed out from the server? Let's be clear on that. And then access and security requirements. Are you only going to allow certain operating system or platforms? Okay, we are only going to support iPhones. We are only going to support Androids. We will only support Windows operating systems or Mac OS. How do you want to slice that, or do you want to? All right. Reporting obligations. When and to whom lost or stolen devices will be reported, and what happens? Okay. The company's right to monitor and protect, monitor messaging systems and data, remote wipe resets, permissible and impermissible uses, and then outline the expectations of privacy the employee may or may not have. Okay. The biggest thing that I want to say, and this is why I'm really presenting more questions than I necessarily am presenting answers here, is that no 2 policies are ever going to be identical. Okay? Because it is so contingent upon the device environment that you have, your networking capabilities, your server's capabilities to monitor wipe, right? So it's really important that the organizations understand their technical capabilities when they're drafting a policy like this. Okay? So you're not going to have a one-size-fits-all policy that you can apply across the board. Okay? Now, I've drafted a number of these policies. I have some samples. If you guys want to email me, I can send you an example, but by no means am I going to tell you that this policy will fit everyone, okay? Because they just aren't out there. But at least provide you some ideas or some things that you need to take into consideration when you draft your own policy, okay? All right, steps to implementation, and then I will pass it. I'm running out of time. Assemble a plan. Okay. Establish the necessary security and other technologies and protocols. Communicate the policy to those employees, right? Let them know what you're going to do and how you're going to do it. Obtain their acknowledgement and consent, right? That's the handbook piece. Have them sign a policy or include in your handbook that they acknowledge it, okay? So go ahead and update the other employment policies at the same time. So or update your wage and hour policies, your EEO policies, document retention, fit and mesh with your BYOD. Okay? And then you can roll it out, enforce, and support. Okay? So ensure that you've got the technical support in place to deal with it. All policies you need to be uniformly and fairly enforced with all employees so you don't have problems with equal treatment across the board, and then monitor and revise as necessary. Okay? How many, I would bet the people that raised their hand out there with BYOD didn't have a watch policy yet, right? How are you going to deal with smart watches and my Apple Watch here? What are we going to do with that? How about information that's stored on a watch? Because that probably wasn't a policy that we even needed to consider here 6 months ago, right? So different devices are going to show up in your environment, so you need to continue to revise that policy. Okay? If you want to go on Google, there is if you search White House DUI Toolkit, there's some good information out there. Or if you search an IT manager's toolkit, it has some DUI stuff in it too that is useful. Okay? Any questions at all? I know I covered a lot of stuff. Yeah.
This sort of goes back to when we were talking about annual meetings and minutes and transporting notices electronically. Are there regulations out there right now on information that can be placed on a nonprofit's website? And I'm thinking primarily about the articles of incorporation bylaws, our 990s. Should we be putting board minutes?
Can you repeat the question?
Yeah, the question is about what information should nonprofits, or are there any maybe guidelines or help for publishing articles of incorporation, publishing bylaws, putting 990s on the website, minutes of meetings, things of that nature. And I guess I don't really know of any policies specifically. I mean, it's kind of up to the organization to decide how much they're willing to put out there for the world to see. I always say minutes probably doesn't hurt. If members really wanted to get the minutes, they could get them anyway. But it truly is going to be dependent on what the organization feels comfortable with. 990s they can get on GuideStar. They're accessible anyway, so they can get them if they want to. It's just does the organization want to make it easier for these people to get that information. Bylaws are something that aren't necessarily going to be public. Okay. Now, if you're a member of a nonprofit, and a lot of organizations are going away from member nonprofits, right? So a lot of them are non-member. But if they're a member, they're going to get it. It's just how easily accessible you want to make it. So, other questions? Yes, Mr. Sardock.
Where exactly is Lyle, Minnesota?
Lyle, Minnesota is south of the metropolis of Austin, Minnesota.